Good morning, everyone. Thank you all for being here. My name is Rika Edwards. I work as a civil rights specialist in the Civil Rights Division of the Civil Rights and Equal Opportunity Department. Today's webinar topic is the Pregnant Workers Fairness Act, and our speakers are Jaime Guillen, who is the Director of the Civil Rights and Equal Opportunity Department, Jana Lomax, who is a Civil Rights Investigator, and Erica Simon, who is with the Wage and Hour Division at the Department of Labor. Our first speaker will be Director Guillen.
Good morning, everyone. Thank you for joining us this morning. Hope everybody enjoys this webinar and is provided great information. I just kind of want to do a quick introduction of our department. As Rika stated, the Civil Rights and Equal Opportunity Department has three main functions. One specifically being our Civil Rights Division, which investigates complaints of discrimination in employment and public accommodation, and recently took on the local version of the Pregnant Workers Fairness Act. So that's our Civil Rights Division. We also do prevailing wage and workforce enforcement, as well as MBE, WBE certification and monitoring. So that pretty much gives a brief summary of the functions of the CREO department. And I welcome you this morning, and please ask questions and reach out to us if you need anything else. With that, I will turn that back over to Rika so we can proceed with the program. Thank you.
Sounds great. Thank you, Director. Our second speaker today is our guest speaker, Erica Simon. She will be presenting on the Pump Act.
Good morning. Thank you for having me come and speak today about this important protection. Breastfeeding can provide important nutrients to help infants grow, protect against common childhood illnesses, and improve survival rates during a baby's first year. Work should not be a barrier for women who want to breastfeed, for example, because of inflexibility in their work hours or lack of privacy to pump. In some circumstances, nursing employees may even be discouraged from taking pump breaks and encounter hostility or retaliation. For more than a decade, the Fair Labor Standards Act, the FLSA, has provided covered employees with the right to pump breast milk at work as needed, in privacy, without fear of retaliation or losing their job. The Providing Urgent Maternal Protections for Nursing Mothers Act, the PUMP Act, was passed in December of 2022, and this act extended coverage of these important worker protections to millions of workers, including teachers, nurses, farm workers, and many more. The Pump at Work protections also include remedies for employees whose rights are violated. Throughout this presentation, the main topics that we're going to cover is who is covered by the Pump Act, its break time and space requirements, what exemptions may apply to businesses, prohibitions on retaliation against employees, information on enforcement of the law, and available resources for complying with the requirements. We will also hopefully have some time to take some questions at the end. This is just our required disclaimer slide. Basically, that says that the presentation is intended as general information only and does not carry the force of legal opinion. The Fair Labor Standards Act is a federal law that sets minimum wage, overtime, and child labor standards for most private and public employers. The FLSA also requires employers to provide reasonable break time for a nursing employee to express breast milk for their nursing child for 1 year after the child's birth, each time such employee has need to pump at work. Employees are entitled to a place to pump at work other than a bathroom, which is key, that is shielded from view and free from intrusion from coworkers and the public. This right to pump at work has been available to the employees since 2010, when the Fair Labor Standards Act was amended by the Affordable Care Act to, for the first time, require protections for employees to pump breast milk at work. Because at that time, the pump at work protections were originally added to the Section 207 overtime protections under the law. Employees who were exempt from overtime protections were also exempt from the break time and space requirements. For example, teachers, certain nurses, and farm workers were not covered. Additionally, the law generally limited recovery for violations to unpaid minimum wage and overtime pay. On December 29th, 2022, the Pump Act was signed into law. The Pump Act amended the Fair Labor Standards Act by striking the Section 7R, which was the overtime section, and moving the provisions for break time and space for nursing employees to a new Section 18D of the Act. As a result of this change, most workers who were previously exempt from the Pump at Work protections of the FLSA are now protected. The Pump Act also improved employee access to remedies if an employer does violate the law. While the Pump Act extended employee eligibility to pump at work and increased access to remedies under the Fair Labor Standards Act, it did not change the break and space time requirements that previously existed under the law. Okay. So we have two different types of coverage that apply under the Fair Labor Standards Act. And I'm not going to spend a ton of time on this, but I'll certainly be happy to answer questions about it a little bit later. And the reason it matters, again, is because it's going to affect what employees are subject to the pump requirements. So we have an enterprise coverage concept, and that is where you have any type of an enterprise or a business that does at least $500,000 a year in annual dollar volume or business, and has at least 2 employees that are handling goods or materials that have moved in interstate commerce. We also have what is called named coverage, and that's where you have the entity is engaged in the operation of a hospital, residential, medical, or nursing care facilities, schools, preschools, or any public agency. We also have a concept for coverage called individual coverage. So when enterprise coverage does not exist, we look at under the Fair Labor Standards Act, is that employee in any given work week engaging in duties or activities that involve interstate commerce activities? So some examples that are listed here on the slide. If you have someone that is making out-of-state phone calls, receiving or sending interstate mail, email, ordering goods across state lines, that type of thing, then they're going to be covered in any weeks in which that is happening. Domestic service workers, such as housekeepers, full-time babysitters, and cooks, are normally covered by the law in that domestic service worker capacity. Okay, so in looking at what is reasonable break time, the Act provides that covered employees with the right to take reasonable break time to express breast milk for their nursing child. Again, this right exists for 1 year after the child's birth. Covered employees may take reasonable break time each time such employee has the need to express the milk. An employer may not deny a covered employee a needed break to pump. The frequency and duration of breaks needed to express milk will likely vary depending on factors related to the nursing employee and the child. Factors such as the location of the space for pumping and the steps reasonably necessary to express breast milk, such as pump setup, can also affect the duration of time an employee will need to express milk. The main thing to remember about this is that it's not going to be a set amount of time. It may vary from individual employee to individual employee, and the amount of time needed may vary from day to day, week to week, and even individual instance to individual instance. In addition, employees who telework are eligible to take pump breaks under the Act on the same basis as if they were working on site. Just a couple of examples of what would be reasonable break time. So, for example, Irina and Leslie have different break needs. Irina, a shift manager at a fast food restaurant, takes 4 25-minute pump breaks each day when she first returns to work after the birth of her child. Leslie, a department store delivery driver, has a 9-month-old baby and needs 2 30-minute pump breaks each day she works. As these examples show, individual circumstances will vary. An employee may take a break to pump more frequently than 4 times a shift and for longer than 30 minutes if needed. Under the Fair Labor Standards Act, covered employees must be paid for all hours worked in a work week. In general, hours worked or compensable time under the Act includes all time an employee must be on duty or on the employer's premises or at another place of work, including a telework location, from the beginning to the end of their workday. Rest periods of short duration, usually 20 minutes or less, are common and customarily paid for as working time. When employers provide paid breaks, an employee who uses such break time to pump breast milk must be compensated in the same way that other employees are compensated for break time. For example, Madison works on a farm. Madison's employer provides all employees with 2 paid 15-minute rest breaks each day. If Madison chooses to use both of the paid 15-minute breaks to pump breast milk for her 6-month-old infant, if she needs additional breaks to pump, the additional break time does not have to be compensated as long as Madison does not perform any work during those breaks. Moving on to the space requirements. Covered employees must be provided with a place, and I will emphasize this again, other than a bathroom that is shielded from view and free from intrusion from coworkers and the public, which may be used by an employee to express breast milk. Under the Fair Labor Standards Act, a bathroom, even if private, even if it has a lock, even if the employee can shield themselves, is not a permissible location by regulation under the Act for the employer to provide the pumping breast milk. The location must be functional as a space for pumping. If the space is not dedicated to the nursing employee's use, it must be available when needed by the employee. So a key takeaway there is it doesn't have to be a dedicated space, absolutely can never be a bathroom, and it has to be available whenever the employee needs it to pump. The Fair Labor Standards Act requires that employees have a private space to pump that is free from intrusion. As such, employers must ensure nursing employees are not walked in on when taking pump breaks. Employers may ensure the employee's privacy, for example, by displaying a sign when the space is in use or by providing a lock on the door. Employees who telework have the same right to privacy during pump breaks as other employees, and their right to privacy includes freedom from being on camera. Employees should be free from security, computer, and web conference cameras when they break. And of course, that would apply to both telework and on-site workers. The Pump Act added a new privacy protection for nursing employees on rail carriers working on passenger trains by allowing such employees to temporarily obscure the view of recording devices when the train is not moving. This new protection was effective December 29th, 2022, with the enactment of the law. Okay, in looking at the functional space requirement, the space provided for the employee cannot be a bathroom again, and you're going to hear me keep repeating that, and it must be usable or functional for pumping breast milk. Features that improve the functionality of the space provided for pump breaks include, for example, that there is a place for the nursing employee to sit, there is a flat surface other than the floor where the employee can place their pump, there is access to electricity for the pump, and there are sinks nearby where an employee can wash their hands and clean the pump attachments. An employee should also be able to safely store the milk, such as in an insulated food container, while at work. The amount of time that is reasonable for a nursing employee to express milk is dependent in part on access to the suitable space. How far the space is from the employee's workstation and other factors, such as additional features that may make the process work well for nursing employees. Employers should also take into consideration the number of nursing employees and their work schedules to determine whether more than one space should be designated or created. For example, while the Fair Labor Standards Act does not require that employers create permanent dedicated spaces for employees' pump breaks, some large employers may choose to do so, for example, by including dedicated room on each floor of a multi-storied building to accommodate the pumping needs of significant numbers of nursing employees. This is just an example regarding space. Marin, a logging company employee, uses a company break room. The room is shielded from view. In this case, it has a window with blinds that she can close. She can lock the door so it is free from intrusion when she uses it for pump breaks. Marin's employer must make the space available each time she needs to pump, but it is not required to have a separate designated permanent space. So now that we've talked a little bit about what the requirements are and who it applies to, I want to talk about some of the exemptions and the exceptions. There is a concept under the Act called an undue hardship exemption from the pump at work requirements that is only available to certain employers with fewer than 50 employees. To access or utilize the exemption, these employers are required to demonstrate that complying with the law would cause a significant difficulty or expense when considered in comparison to the size, financial resources, nature, and structure of the employer's business. Employers with 50 and more employees are not eligible to claim this exemption. All employees who work for the covered employer are counted. As an example, an employer that owns and operates a business with 2 locations with 25 employees at each location would be considered to employ 50 employees. So it's based on the total number of employees for the entire company, not on a location by location basis. The air carriers, I'm not going to spend a lot of time on that. If you guys have questions about it, we can come back and revisit it. Just be aware that the pump requirements, protections do not apply to crew members of air carriers, and that means a person assigned to perform duty in an aircraft during flight. Rail carriers and motor coaches, again, I'm not going to spend a lot of time on this, but just do be aware that the pump protections generally do apply to employees of rail carriers or motor coach services as of December 29th, 2022. However, coverage for certain employees of rail carriers and motor coach services begins on December 29th, 2025. That would include employees such as train crew members involved in the movement of a locomotive or rolling stock or who maintain the right of way of a rail carrier, and employees involved in the movement of a motor coach. Even once the pump at work protections are applicable to those employees on December 29th, 2025, there will be an exception to these protections that may apply if an employer demonstrates that compliance requires significant expense or results in unsafe conditions. In terms of interaction with state laws, many states have laws related to pumping milk at work. Employees may have greater protections under their state or local laws or ordinances. The FLSA provides that the reasonable break time and space requirements do not preclude greater employee protections provided under these laws. For example, some states may require that all breaks for pumping be paid or may require that breaks be made available for more than 1 year. The basic rule, just like with anything else, is that employers are going to be required to follow the more stringent law or requirement. Under the FLSA, retaliation for a multitude of things under that act are prohibited to include the pump requirements. So the act itself prohibits retaliation, harassment, intimidation, or the taking of adverse or disciplinary actions against employees for inquiring about their rights, including the right to pump at work, for asserting those rights, or for filing a complaint or cooperating with a wage and hour division investigation. Retaliation occurs when an employer, through a manager, supervisor, administrator, fires an employee or takes any other type of adverse action against an employee for engaging in a protected activity. An adverse action is an action which would dissuade a reasonable employee from raising a concern about a possible violation or engaging in other related protected activity. Employees may make a complaint orally or in writing, and most courts have also ruled that internal complaints to an employer are also protected. So just be aware. I know you all are familiar somewhat with FMLA, and this is very similar. So when someone is asserting their rights, asking questions when they participate in a wage and hour investigation, those employees can't be treated differently. Those employees can't be retaliated against. There, you can't have that creep in there of this factoring into decisions that are made about that employee. Just as an example of what would be prohibited retaliation, Leslie's employer complains that her pump breaks are interfering with the delivery schedule and they move her to a lower paying job. This is a violation of the protections against retaliation. Leslie cannot be removed from her job as a delivery truck driver because of her request to pump at work. The employer is required to provide Leslie time and a private space to pump each time she needs it in the first year after her child's birth. Employers are prohibited from taking an adverse action against employees for inquiring about or asserting their rights under the Act, including the right to pump. So in terms of what happens once we have any violations, at that point, we would look at what remedies are available. Beginning April 28th of 2023, an employer who violated an employee's right to reasonable break time and space to pump breast milk has become liable for any of the appropriate legal or equitable remedies available under the Fair Labor Standards Act. These remedies may include employment, reinstatement, promotion that was denied, the payment of wages lost, and an additional amount as liquidated damages. It can include compensatory damages and make whole relief, such as economic losses that resulted from the violations, and punitive damages where appropriate. Before April 28th of 2023, remedies for violations of the pump provisions of the Fair Labor Standards Act were limited to unpaid minimum wage or overtime. So there was a fairly significant change that happened as of April 28th, 2023, that made these remedies more expansive for the employee. In terms of enforcement, that is done by the Wage and Hour Division, which is my office. And if an employee's right to pump at work is violated or the employee suffers retaliation related to that right, the employee may file a complaint with the Wage and Hour Division, or they can also file a private cause of action seeking appropriate remedies at any time within a 2-year statute of limitations. The Fair Labor Standards Act also allows a 3-year statute of limitations if the violations are willful. There are special procedures that may apply to filing a private action where an employer has failed to provide an employee with an appropriate space to pump. These procedures do not apply before an employee or other party can file a complaint with the Wage and Hour Division. So before an employee can file a private suit to enforce the right to a private appropriate space to pump, the employee must notify their employer of the failure to provide the required private space and allow 10 days for the employer to come into compliance. This requirement to provide notice does not apply if the worker has been fired for making the request or for opposing employer conduct related to the reasonable break time and space requirements, or where the employer has expressed a refusal to comply. This requirement does not apply when an employee brings a private suit to enforce the reasonable break time requirement. This requirement also does not apply to Wage and Hour Division investigations or for an employee to file a complaint with the Wage and Hour Division. Just some general information about us. As far as how to contact us, we do have a general toll-free number, but I would like to give you all the Kansas City District Office number where you can reach us directly and speak with an investigator on duty if you need to file a complaint or if you have questions about any of the provisions of the Pump Act or the Fair Labor Standards Act. That number is 913-551-5721. And then you can also call this 1-866-4US wage number or visit our website that's listed here for the WHD contact there at the end. And I will come back to that slide here in a minute if anybody still needs it. In terms of the resources that we have available, we do have a very good web page that has information about this. You could look at fact sheet number 73, which is listed among our other fact sheets on our website, and it should be if you go into the FLSA Protections to Pump at Work site. You should have access to those. There are FAQs, information on what to expect when you're expecting. And then we do have some additional resources that are listed to support nursing moms at work. There's some information there about EEOC, if there is any disparate treatment or anything going on with respect to that you could also potentially look at. We have OPM guidance on nursing mothers for federal employees, the guide for establishing a federal nursing mothers program, CDC workplace lactation support program toolkit, and then just different ways that you can connect with us. So any questions? Let me go back and make sure that I have that slide up that has that information. And then do you all have any questions for me?
Erica, we have a question.
Okay.
Can you review the posting requirements for employers? Is there a separate posting for the Pump at Work Act?
I don't believe that there is. It should be contained within the updated Fair Labor Standards Act poster, but I can certainly take a quick look before the meeting's over and make sure.
Thank you.
Thank you.
You're welcome. And I know I threw a lot at you guys. So if you guys have any questions afterwards, like I said, you can call that Kansas City number and you'll speak to whoever the investigator is on duty that day. But I'm happy to also give you all my number to reach out if you have any questions. And my extension is 913-689-3294. Okay. Has everybody
Thank
got
you, Erica.
what you need off the slide? I'll go ahead and stop sharing.
Perfect. Thank you so much.
Thank you.
That was very informative. And next we'll have Jana Lomax, who is a senior civil rights investigator.
Good morning. My name is Jana Lomax. I'm a senior civil rights specialist and investigator with Kansas City Civil Rights and Equal Opportunity Department. And today I'm going to talk to you a little bit about the Pregnant Workers Fairness Act. Okay, so on February 1st, 2024, the City Council passed amendments to Kansas City's ordinances for non-discrimination, supporting the health and economic security of pregnant workers employed within our city limits. The city's ordinance mirrors the federal Pregnant Workers Fairness Act, which requires covered employers to provide reasonable accommodations to a worker's known limitations due to pregnancy, childbirth, or related medical conditions. So, who are the covered employers? The employers must be located within the city limits of Kansas City, Missouri. They must have 6 or more employees. This includes employment agencies and labor organizations, and religious organizations are exempt from this provision. Okay, so under this new law, it is considered a discriminatory act for an employer with more than 6 employees or an employment agency located within Kansas City to refuse reasonable accommodations for a qualified employee's known limitations related to pregnancy, childbirth, or related medical conditions, unless it causes undue hardship to the business. It is a discriminatory act for an employer to force a qualified employee with pregnancy-related conditions to accept accommodations other than one reached through the interactive process. It is a discriminatory act to deny job opportunities to a qualified employee because the company needs to make reasonable accommodations for pregnancy-related conditions. It is a discriminatory act to make a qualified employee take leave when there's another reasonable accommodation for their pregnancy-related conditions available, or to penalize a qualified employee for requesting or using reasonable accommodation for their pregnancy-related conditions in terms of employment terms, conditions, or privileges. So, if a qualified employee finds it harder to perform their job due to pregnancy, childbirth, or a related medical condition, this law empowers them to ask their employer for a change or adjustment to a job or work environment that allows them to have equal opportunities and perform their job duties. Some examples of a reasonable accommodation are light duty work, a chair to sit on while working, telework or flexible scheduling, temporary reassignment, leave for healthcare appointments, changing food or drink policies to allow for food or water, additional breaks to eat, drink, or use the restroom. The accommodation can really be about anything. It just depends on the circumstances. So asking for a reasonable accommodation should start a discussion between the employer and employee about the medical condition and the employee's work needs so that both sides can find the best solution for the work to be completed. This discussion is called the interactive process. An employer is legally obligated to engage in the interactive process with an employee who asks for a reasonable accommodation. The reasonable accommodation process only applies to known limitations, meaning the employer should not assume that a worker needs an accommodation or what accommodation a worker might need. The employee needs to ask for the accommodation, but the employee does not have to use magic words. They just need to inform their employer that they have a condition limiting their ability to perform their job duties. Usually, the discussion can be a simple conversation between an employee and their supervisor. If needed, the employer may request some medical documentation, but there are limitations to what they can ask for. It must be reasonable, such as a doctor's note. It is important to note that employers are not required to make accommodations that would cause them an undue hardship. An undue hardship is a significant expense or difficulty for an individual or organization. In the context of employment and disability law, undue hardship describes the point at which an employer is no longer required to accommodate an employee's needs or disability because doing so would be too burdensome. So you need to consider the resources available and the type of work when asking for a reasonable accommodation. Also, the worker's preferred accommodation may not always be the most reasonable solution from the employer's perspective. So the preferred accommodation may not always be required. The conversation should go back and forth until a good solution for both the employee and employer is found. Of course, it is still illegal to fire or demote a worker due to their pregnancy. This law does not change that. If a reasonable accommodation is not provided in the absence of undue hardship and/or the interactive process is not engaged in, a discriminatory act may have occurred. If that happens, a complaint can be filed on the MyKC app by calling 311 or by coming to the Civil Rights Division office in City Hall. A complainant must file within 180 days of the alleged discriminatory act. Upon receiving the signed complaint, the respondent will be notified to answer to the charges. Mediation is offered to both parties to resolve the issue. Settlement may also be sought. Our investigations include the interviews of parties and witnesses, review of documents, and proof of the interactive process. A right to sue letter can be requested by charging party. If probable cause is found, the case goes to the Kansas City Human Rights Commission for hearing. If no probable cause is found, parties are notified, the complainant is informed of their rights of review, and the case is closed. We have some resources available. Our webpage, www.kcmo.gov/CREO, CREO. Also, a pregnant worker could file if it's a federal case, with the EEOC, eeoc.gov. We also want to mention another resource. It is called askjan.org, askjan.org, that also has resources available for pregnant workers. Any questions?
I have a question, Jana. What should an employer do if an employee asks for breaks, leave, or other changes to work due to pregnancy?
Well, that would be the employee asking for a reasonable accommodation. So the employer should engage in the interactive process, which means having a discussion with that employee to find the best reasonable accommodation for them.
I think that is it. Thank you so much, Jana.
Absolutely. Thank you.
Well, thank you to everyone for coming out and listening to the webinar today. This recording will be posted on the CREO webpage, so please visit it if possible. And there's more information on our CREO website. So if there's anything you need, please reach out. And thank you so much for joining us.